Hey, and welcome back to the hopefully final section of the my guidance on the draft guidance from the EHRC and the consultation. We've moved on to chapter 13, and hopefully I'll get this done in one video, although it is quite a long section, as you can see. Let's get going. We're still going to start off with sports. And I would say the first point I have is define necessary with regards to objective criteria. So the code should provide clear, evidence-based and sport-specific guidance on what constitutes necessary exclusion for fair competition. Yeah. Yeah. So, it talks about necessary exclusions and the reasons being for fair competition. So, it talks about fair competition and safety. This should include defined thresholds and refer to guidance from international sporting federations where appropriate, specifically considering different sporting levels, i.e., so I guess I'm thinking predominantly about elite sports versus grassroots sports, but there's levels in between. And it should clarify the interplay of legal acceptance. So provide much clearer guidance and unambiguous examples on how the sex-based exceptions and the gender reassignment exceptions interact, specifically and especially given the code's redefinition of sex for trans individuals. So explain how an organizer can distinguish between lawful application of these exceptions and unlawful gender reassignment discrimination. How do you tease that apart? Yeah. So there you go. Let's have a look. 3.1.14. So address unsettled law. In some circumstances, limiting, modifying, or excluding participation of trans people for the reason of fair competition or safety may be necessary to avoid discrimination against other competitors. Yeah, I wouldn't really want a definition of necessary here. Section 195 provides organisers of separate sporting events for men and women with exceptions for sex discrimination when providing separate men's and women's events. The laws on interpretation of this provision is not settled and is therefore uncertainty as to how this provision applies. Besides the fact that that is inaccurate English, it's erroneous. Let's have a look. The provision is not settled and is therefore how this applies. The code should offer precautionary, rights-affirming approach for organisers, prioritising inclusion where safety and fairness rather than leaving a vacuum. It seems completely antithetical to the provision of guidance to simply say the law isn't settled and so it's not certain. It's your job to provide certainty. It's your job to provide guidance in this area. So that's a complete abdication of duty. Let's have a look. What else? Let's move down here. Here we have an example. An athletics club chooses to organise an athletics event that includes women and trans women. It didn't need to phrase it like that. It should have phrased to run a women's athletics event inclusive of trans women, or an inclusive women's athletics event would be a much better way of phrasing that, and not at all incompatible with either side. That's deliberately cruel phrasing. But in any case, the example is highly contentious. It appears to lack established legal precedent. The trans women who participate are significantly faster and have a physical advantage. A woman may be able to bring claim for indirect sex discrimination due to the provider's decision not to limit or modify the participation of trans women, placing her at a disadvantage. Now, if it's going to make claim of this, specifically after suggesting that there isn't adequate case law on anything, then why on earth is it making this claim? An example that's highly contentious and appears to lack established legal precedent in this form, and actively discourages trans inclusion. It creates a profound legal uncertainty for any organisers that wish to be inclusive, and it should be removed. And if it is retained, it should be heavily qualified with extremely high evidential burdens, showing for choosing that approach. And for such a claim, and how it balances against gender reassignment protections, because this is completely antithetical to what the guidance should be doing. Yeah, there we go. That's an awful example. 3.1.18. If the code is to mention medical intervention, it must provide detailed ethical and practical guidance on how this factor should be considered. So given the physiological differences between men and women, it will often be necessary for organizations to develop general policies and to guide and inform their decision making in this area. Policies should be supported by clear rationale and evidence-based, and will often draw upon guidance from sporting authorities. Relevant factors may include whether an activity is primarily competitive or competitive but with significant social and recreational purpose, and whether it is a mass participation event, whether there are any safety factors such as those arising from physical contact between men and women, the extent to which there are competitive advantages arising from base physiological factors such as physical strength, stamina, and physique, whether such competitive advantages can be sufficiently reduced through medical interventions such as drugs to reduce levels of testosterone to make competition fair. You know, the talk of medical intervention, if the code is going to mention medical intervention, it should provide detailed ethical and practical guidance on how that factor should be considered, because what evidence is appropriate, how to avoid intrusive and discriminatory practices. You know, it's okay. Yeah, the requirement for surgical interventions. What's valid? What isn't valid? Reference to established policies by relevant sports bodies and governing bodies would strike me as being essential. There's no differentiation by sport. There really needs to be. The code doesn't do it. Doesn't really differentiate. In fact, it doesn't really even say what the athletics event is. This could be a baking sale or anything. It could be, the deliberately vague language in these examples are designed to create a general chill. It would seem. In any case, that's the effect that they will have. Again, consultation with trans athletes. The entire chapter requires urgent and extensive consultation with trans athletes. Yep. And it also needs to emphasize evidence-based approaches. And there's plenty of relevant evidence with regards to sports science. And that sports science needs to pertain to people genuinely of that category. It's not adequate to compare cis men to trans women and intersex people. So I'm going to move on now to the next question, which is question 39, and change 13.2, which is the updated section on separate and single-sex services for men and women. This is really a bread and butter part of the guidance, really quite an important part. Yeah, so basically the first part, it allows for service providers to provide separate facilities for men and women, exclusively for men and women, or to people of a particular age group in certain circumstances. If a service is generally provided to persons who share a protected characteristic, a person who normally provides that service can insist on providing it in a way they normally provide it, refuse to provide a service to people who do not share that protected characteristic. if they reasonably think it's impractical to provide it. Yeah, so the Act, so this relates to separate services for men and women. Does the Act, Section 3, paragraph 26(1), does not prohibit sex discrimination where a service provider, including a person providing assistance in the exercise of public functions, offers separate services to men and women with in specific circumstances. It is lawful to provide separate services if a joint service for men and women would be less effective, or providing a service separately to men and women is a proportionate means of achieving a legitimate aim. These conditions do not apply if the provision of a separate service is likely to be unlawful sex discrimination. These conditions do not apply if the provision of separate sex services is likely to be unlawful sex discrimination. Well, I think probably, quite possibly, in these circumstances, that would encompass all of them. But there we go. Yeah. Some of the issues with this, I'm not going to read through, but that's the general thrust of the section. So in 13.2, the code's explanation of when a service can be legitimately single sex, so based on biological sex, lacks clarity. And when contrasted with the common and accepted practice of staff members, cleaners, maintenance of one's biological sex entering facilities, I'm sure we've all seen signs saying mixed sex cleaners. You might find, men in this bathroom cleaning it. You might find women in this bathroom cleaning it. Whatever. Is that now not allowed? This needs to be made explicit. Are we now designating that that's not the case? And if we're not designating that that's not the case, on what basis are we restricting access to trans people? If we're not allowing the establishment of spaces where these people can go in, and then we need to consider the effect that will have on frontline service providers. I mean, if you say you run a cinema or let's say a small theatre, are you now going to have to ensure that at each time you have to have male and female members of staff on site so that they can man the facilities? Are you going to have male and female cleaners on site to clean the toilets? You're going to have male and female staff for all of the other sex segregated facilities that you might have. How does that work? That's not covered. So yeah, and also if we are allowing that, then how was the allowance of trans people into those facilities going to change anything? That inconsistency needs to be explicitly reconciled. Address safety and dignity when trans people use the facilities aligned with their baby genitals. That's essentially what it comes down to. If the implication of this chapter, so read together with chapter 2, is that trans people should use facilities aligned with their biological sex at birth, so e.g. a trans woman in men's changing rooms, that's implied by condition 5, paragraph 13.218 and 13.219. Here we go. Then this chapter must clarify the service provider's responsibility for ensuring that trans persons' safety, privacy, and dignity in that space. So what steps do they have to take to prevent harassment, violence based on their gender reassignment or perceived sex? I mean, this is an inevitable outcome of placing trans women with men in separate accommodation facilities like that. Less so with trans men with women, I would imagine. However, that will have its own safety issues. Like we talked earlier on about people following trans men into facilities to try and protect the women inside. So, it's just different areas, the same flashpoints. But yeah, that implication hasn't been addressed. Neither has the gender reassignment protection. That's that should be covered. So provide explicit clarity on how a service provider's decision to offer separate or single-sex services based on biological sex, thus excluding trans people from services aligning with their gender identity, how that interacts with their absolute duty to avoid discrimination and harassment based on gender reassignment. That's both in the Equality Act, but then also under various sections of the Human Rights Act to for example, if a trans woman is excluded from a woman-only service because that's defined by the code as a biological female-only space and directed to a men's or mixed-sex service, how are her rights under the gender reassignment characteristics protected in this direction if it causes her stress and outs her and places her at risk? Because the code is silent on that. Define legitimate aim and proportionate means in the context of trans. This is a really important issue, I think, because the code keeps on stating that providing separate single-sex services must be a proportionate means of achieving a legitimate aim. It must provide clearer guidance and specific examples on what constitutes a proportionate means of a legitimate aim, and the consequence of and if the consequence of excluding a trans person who may have a GRC or may not hold a GRC, but accessing services that they previously accessed, if it can truly ever be a legitimate aim, if it can truly ever be legitimate and proportionate, if it places somebody in extreme harm of discrimination and outing and danger. But also, if it's a proponent means to achieve a legitimate aim to sex segregate facilities for cisgender people, is it not also a proportionate means of achieving a legitimate aim to sex segregate for those trans people? I guess the argument I'm making here is if a service provider is to provide third spaces, neutral spaces, let's say I have a gender neutral change room that anybody can use. I've got a men's change room, a women's change room, and a gender neutral change room. Like in those spaces, that is not an adequate provision, because if we're saying to trans people, to trans women, you can either go in with the men, but we accept that you're going to be in danger there. So that's not proportionate. And we say the same to the trans guys. We can't just say, well, you can both go into this gender neutral space. Because they have the same rights to protections as cisgender people in terms of sex segregation from each other. So you would need to provide a fourth space as well, and potentially a fifth space for those who don't fit into either of those spaces as well. So the whole third space solution and providing gender neutral spaces is really something of a red herring. The only way of operationalizing that would be moving completely to independent unit facilities where each room is an independent facility. But I digress. In any case, yeah. Let's see. So clarify the interaction with gender reassignment. I think I've already covered that. Sorry, I'm going to get on my list. The code states that providing separate single-sex must be a proportionate means of achieving a legitimate aim. Strengthen guidance on gender-neutral alternatives. So for true clarity on legal responsibilities, and let me go to the condition, allowing single-sex services where a man and a woman might reasonably object to the presence of a man or vice versa, especially where people are undressed or vulnerable, needs far greater clarity in the context of trans people. So given the code now defines a trans woman as a man for the purposes of the Equality Act, does this mean a cisgender woman's objection to her presence in the women's changing room is automatically deemed reasonable by the EHRC? So it is likely to be reasonable for a woman to object to the presence of a man if she'll be getting undressed or in a vulnerable situation. So, I mean, that's really vague here. Are they just suggesting that that any objection to the presence of a trans person or somebody deemed to be trans, that is automatically reasonable? And are there any factors that go into determining somebody's reasonableness? What are the factors? How much does somebody need to look like a gender to be disallowed for their presence to not be reasonable? Yeah. Anyways, the guidance needs to be on gender neutral alternatives. So there should be more forcible stating that single-sex services based on biological sex are invoked, that there needs to be a clear provision of gender-neutral facilities, and before you can start excluding anybody from sex-segregated options, because that's just, because it would never be a proportionate means to ban somebody from all versions of their facilities, and to ban or to relegate somebody from facilities that are dangerous to them. The code needs to explicitly address GRCs. I mean that's again. I mean I'm gonna raise it there. I won't bother explaining it further, but I will raise it where it comes up later on as well. And again with consultation, there should be evidence of consultation. Okay, I'm going to move on to section 13.3. Section 13.3 is on the justification for separate and single-sex services. So, yeah. So I'm going to skip ahead a little bit in here. It's talking about when you might want to separate out the different types of services. If a service provider admits if a service provider or person providing a service to the in the exercise of public functions admits trans people to a service intended for the opposite biological sex, then it can no longer rely on exceptions set out in paragraphs 13.23 and 2.22. This means that if a service provided only to women and trans women or only to men and trans men, it is not separate sex or single-sex services under the Equality Act 2010. A service like this is very likely to amount to unlawful sex discrimination against people of the opposite sex who are not allowed to use it. This is essentially just banning trans people from all services aligned with their sex, with their acquired sex. A service which is provided to women and trans women could also be unlawful sex discrimination or lead to unlawful harassment against women who use the service. Similar considerations would apply to service provided men and trans men. Now, if a service provider admits people on this basis, it states that being trans inclusive in a women's service, for example, automatically makes it discriminatory against men who are excluded and potentially against cis women who share that group with them. That assertion lacks any clear established legal precedent for many common scenarios, and it needs robust legal justification within the code because it's a much broader application than suggested in the Equality Act ruling. The assertion lacks any legal basis in that, and it certainly hasn't asserted one. So it's not clear on what basis the trans women in a women's service is very likely to be sex discrimination against men, and when the men were never intended to use that service in the first place, and how could it be sex discrimination or harassment against other women if done inclusively and with consent? It creates a chilling effect on any service, even if they wish to be inclusive of trans people within a single-sex service, effectively making it legally perilous for them to include any trans people in a service. And that conflicts with the idea of a holistic approach. It talks in 13.310. But if the only safe way to operate a single-sex service is to exclude trans people who live in that sex, how can that possibly be holistic. And to be honest, if it can be a proportionate means of achieving a legitimate aim to exclude trans people from a group, then it must be a proportionate means of achieving a legitimate aim to remove cisgender men from that same group. It will be a proportionate means of achieving a legitimate aim to have what the Equality Act would consider a mixed sex group and remove cisgender men, and to remove potentially trans men from that group as well, depending on the type of group it was. I don't see at all why that would be not a proportionate means of achieving a legitimate aim. Yeah, so 13.3.19 must be removed or completely rewritten to reflect a nuanced understanding of the law, because any assertion that including trans people in a single sex service aligned with their gender identity is very likely unlawful sex discrimination needs to be clearly substantiated with legal reason and case law, or removed. The code shouldn't actively discourage or misrepresent the legality of inclusive practices that many service providers currently and successfully employ. So that's completely inappropriate. Yeah. 13 point, I'm going to skip back to a few of the ones that I missed on that point. 13.3, while it mentions that considering the disadvantage to trans people, 13.37, the weight given to this disadvantage. Here we go. So the impact of those who will be excluded from a service includes both the impact on people of the opposite biological sex generally, and the particular impact on trans people of the opposite biological sex. In separate or single sex services, a trans man will be excluded from the men only service because of his biological sex is female, and a trans woman will be excluded from the women only service because her biological sex is male. Trans people are likely to be disadvantaged by this, but comparison to people by comparison to people who are not trans. Now, what it mentions, considering the disadvantage, the weight given to this disadvantage versus the legitimate aim is completely unclear. And the code should provide clearer, well, I say clearer, it doesn't provide any guidance, but clearer, stronger guidance on how to weigh the disadvantages to trans people in the balancing exercise. It should specify that a legitimate aim, say, for example, for the purpose of privacy or safety, is unlikely to be achieved proportionately if the measure taken result in severe harm, denial, or dignity, or significant safety risks to trans or intersex individuals or gender non-conforming individuals, because that would breach the PSED obligations, the duty of care, gender reassignment obligations, and the Human Rights Act under Articles 3 and 8. So, you know, these aren't small issues, and it's just completely skipped over them. The threshold for justifying the exclusion of trans people from services aligning with their lived gender must be exceptionally high and evidence-based. Again, it should call for evidence-based here, and to be honest, it should be drawing on the evidence to demonstrate this. But the fact that it's devoid of evidence is leaves things vague, very vague, and it leaves things completely open to everybody's interpretation. Is antithetical to the production of a guidance. Okay, let's have a look at 3.11. This is this change here. Example, a service provider operates a shopping center and decides to renovate the center. It initially intends to provide only separate sex toilets to improve the safety and comfort of all users. This disadvantages trans people because it means that trans person cannot access a toilet catered towards their acquired gender. It's not really the problem. The service provider therefore decides to also provide toilets in individual lockable rooms can be used by people of either sex. Now, the shopping center unisex toilets and advice center repurposing accessible toilets, which is the following one. The community group is an open small advice center. It decides to provide separate sex toilets for men and women. It repurposes the accessible toilet to be used as a mixed sex toilet for anybody who does not wish to use a toilet for their biological sex. This is likely to be proportionate given the size of the resource, and the centers takes into account the needs of the potential service users. This is it's presented as a positive decision, but the code has to be clearer about where a service provider legitimately provides a single-sex service that excludes trans people. There is a proactive legal and ethical responsibility to simultaneously ensure the provision of safe, accessible, equivalent, and clearly signposting gender-neutral single-stall toilet alternatives is a core component of demonstrating a proportionate means, and that should be made clear. That if you cannot demonstrate that, then there is no way that you're going to be able to demonstrate that it's a proportionate means. To be honest, 13.312 is problematic because if it describes repurposing an existing accessible toilet as a sufficient solution, then that will disadvantage disabled people. As you know, alternatives for trans people must generally be considered separately. It doesn't consider the fact that often these facilities are radar key locked, and rightfully so. Radar keys secure disabled facilities to make sure that things like hoists work and haven't been vandalized. You know, that facilities with grab bars and other safety precautions like ground level pull cords haven't been disabled or wrapped around the hand cords, as happens when they're in more sort of open spaces. These are important initiatives. We didn't invent the radar system because we just felt like it would be really cool to just keep people out for no reason. You know, the presentation of the repurposing of disabled spaces is problematic at the very least. At the very least, yeah. Yeah. So 13.317. This example. So this provides two gyms. A women's centre provides gyms predominantly used by Jewish women who have religious objections to sharing gyms with men. The gym considers whether to open the gym to men on certain days or to open the gym on mixed sex days. And then 13.317. However, the centre decides to offer the gym only to women because of overwhelming demand for the service from Jewish women, and therefore there are numerous other gyms in the area that cater to men and trans people. This service would exclude men and trans women, but is likely to be proportionate and lawful. This example concludes that the exclusion of men and trans women is likely to be proportionate and lawful because there are numerous other gyms in the area that cater to men and trans people. But clarity is needed on the legal standing of relying on other service providers to meet the needs of an excluded. What if adequate alternatives for trans people don't exist locally? Or what if they close? The code must clarify a service provider's primary responsibility for the impact of its own exclusionary policies. So, yeah, that's important. In 13.3.18, the code should make it clearer that the service providers must rigorously document their justification for single-sex services that exclude trans people and intersex people or gender non-conforming people, including their balancing exercise. So, you know, it's not enough to make these things up afterwards. There needs to be a clear evidence for legitimate aims, consideration of alternatives, and specific consultation with trans and individual groups. This should be a requirement before an organisation can implement a measure that it states is a proportionate means of a legitimate aim. How could it be a proportionate means of achieving a legitimate aim if it hasn't consulted with the LGBT community, if it hasn't consulted with the intersex community and other affected communities? It couldn't be. Yeah. 13.3, 13.3.20. Right. This states that providing mixed-sex services could be discrimination or harassment against women in some contexts. Now, the code must clarify that providing well-managed, safe, mixed-sex services alongside sufficient, adequate, genuinely private, gender-neutral, single-sex stall options is the most inclusive and least discriminatory approach overall. So that means that you can provide inclusive facilities and allow for single, that is to say, what they call unisex. There's a distinction between unisex facilities and gender neutral facilities in law. Unisex facilities are those facilities that are completely self-contained, that are demarked by floor to ceiling walls and containing its own basin, its own wash basin, where we talk about bathroom facilities. So the most accessible and most inclusive facilities are those that are inclusive and then offer those single-sex stall options in addition, single occupancy stalls. So clarity should be provided on that, and that would actually be a really positive thing to put forward that would resolve many problems in many contexts. So I'm going to move on to 13.4. Before I do that, I'm going to take a break though, because I think we're about the time now. So I'll see you in the next video.